So we are good to go.
Okay. So do you want to let me share my screen?
Yes, I will.
I think I can. There we go.
Yep.
All right. So today we're going to talk about the dirty secrets of why your estate plan may fail. And so I'm Cindy Nelson. I'm an elder law attorney. We have offices in Marietta and in Woodstock. And we've been doing this for quite some time now. We've been able to help over 2,000 families. You can see we've won some awards. Customer experience is really important to us. We know that when someone comes to us, they're going through a difficult time, and we want to make sure that we make it as easy as possible on them. So what we're going to talk about today is, like, what is an estate plan? We've all heard of it, but what does it really mean? And why is it going to fail? So I'm going to give you 10 reasons that happen pretty frequently that cause the estate plans to fail. So first, let's talk about what is an estate plan. Well, it's just legal tools for you to identify what you want to happen with your assets after you die and while you're still alive, for people to make decisions for you. A basic estate plan includes a medical power of attorney. It also includes a living will and a HIPAA authorization. Sometimes those are in the medical power of attorney, but I really like them to be separate. Then a financial power of attorney and a last will and testament. You have to have mental capacity to implement an estate plan. Now, mental capacity is something that's very fluid, so I'm going to take a minute to talk about that. Even though you might be diagnosed with some type of cognitive impairment, that does not mean that you don't have the capacity to create these legal tools. You just need to understand what you're doing at the time, and the threshold is actually different for each of these documents. So the lowest threshold is to make a will, which is surprising. We'll talk about that too. So what happens if you don't have an estate plan? Life is going to be much more stressful and difficult for the people that love you, not necessarily for you, because you're not going to understand or maybe even know about the stress and the expense and the difficulty. But for people that love you, it's going to be much more difficult. If you lose capacity, your loved ones would be required to petition the court to get the authority to make decisions for you while you're still alive. And this process is called a guardianship. It usually takes several months and costs thousands of dollars. So if you can imagine, especially in the world that we're living in today, you have to go to the hospital. Most of the time, nobody can go in with you now. And so if you're sick enough to need to go to the hospital, you're also too weak to be your own advocate. But you're going to be in there making decisions. If you don't have documentation on what's important to you, or who the doctors can talk to, or what kinds of treatments you want or you don't want, then it's really difficult for you to advocate for yourself. And if your loved ones don't have the proper authority, then there isn't anything that they can do to help you. And that doesn't seem to happen as much for medical decisions as it does for financial decisions. So if you want to decide who's going to make decisions for you and not let the court decide that, you'll want to get some of these tools in place. Now, we all talk about a will. I think everybody's heard the word a will, but what does it actually do? And it's just a tool to transfer whatever assets you own at the time of your death to beneficiaries. And with the will, you get to choose who those beneficiaries are And you also get to choose who's going to be the executor. A will does not avoid going to probate court, and this is a very common misunderstanding. So if you have a will and you think that your family won't need to go to probate court because you have that will, that's not necessarily the case. Without a will, the state decides who inherits your assets and who's going to be the manager or executor of your estate. And it might not be the people that you want to get the assets or to be the executor of the estate. So dirty secret number one, your estate plan fails if you do not have a recent financial power of attorney. So we all know that financial institutions are much more scrutinizing today than they've ever been in the past. Even if you are the spouse of the person, they're not going to let you do things for them. I use the example, most of us have called Comcast and tried to get something done when it's not an account in our name and have suffered immensely for that. So you need a financial power of attorney for people to do anything related to your finances if you become incapacitated. So what does that need to have in it? It's got to be very clear on what authority you're giving to someone. The broader it is, the less effective it is. So if I say that I want someone just to take care of my properties, do I want them to be able to lease? Do I want them to be able to sell? Do I want them to be able to refinance? What do I really want them to do? It needs to be signed by the creator, but also by two unrelated witnesses. It needs notarized, dated, the name of the people that you want to give the authority to, and it has to be in writing. Dirty secret number two is if you don't have a medical power of attorney. As I said, a lot of times in a medical situation, they will let decisions be made as long as the family isn't fighting or that type of thing, but they don't always. So you don't want to have a medical decision made that is stopped because people need to go to court. So in a medical power of attorney, it has to say who you want to make decisions for you. I like for all of these people to have a primary and then a backup. You need to sign it. Two unrelated witnesses need to sign it. It has to be in writing and it has to be dated. Dirty secret number three, your estate plan fails if it does not name a living executor. So if I put my brother as the executor of my estate and he predeceases me and I don't have anybody else, then we're going to end up in court because the court is going to have to identify somebody. So my estate plan isn't working the way that I want it to. You should always have a successor. And for this, you need to find somebody that's trustworthy and responsible. Dirty secret number four, your estate plan fails without successor beneficiary. So you're getting the idea here. We got to have backups. If I'm going to leave something to my brother and he's already passed away, then my estate plan doesn't work. So let's say that I have 3 children. I'm going to leave everything to them in equal shares. They all get 1/3. But what happens when one of them passes away before me? How is that handled? If it is not clearly articulated in your estate plan, then again, you end up back in court. Court's always expensive and always takes a long time. Dirty secret number 5, your estate plan is going to fail if it was signed under fraud or undue influence. So remember I told you capacity is varied and it's a moving target. But in the state of Georgia, the lowest level of capacity anybody needs is to make a will. You only have to be 14 years of age. You have to know what assets you own and understand and be clear about who you want to get those assets. Now, a lot of times we'll see family members that will come in with their loved ones and they're trying to influence their loved one to do a specific thing. Like, don't you want me to get the house? blah, 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 I've been taking care of you or whatever. But usually, no, they don't want that person to get the house, but that person is the caregiver and they're sitting in the room. So I like to have the family leave the room whenever I am talking with somebody about what their specific needs are. But we do see a lot of that. And I don't think that it's malicious. I think it's just that they thought they knew what their loved one wanted, and they were trying to encourage them to follow through on what that person thought the loved one wanted. I'm sure there are some times where it is malicious, but I don't usually see that. Dirty secret number 6. Your estate plan fails if you disinherit your spouse. In Georgia, you cannot disinherit your spouse. They're entitled to at least 1/3 of your estate. Plus, they're entitled to 1 year of living expenses before your estate is distributed to any of the other beneficiaries. So you're going to want to make sure that if you've spent time with this person, don't try to disinherit them at the last moment. You need to figure that out while you're still alive. Don't leave this mess for your family, because it doesn't work, and they're going to end up back in court. Dirty secret number 7. Your estate plan fails if your executor doesn't have the original will. So I told you wills need to go through probate court, but you have to have the original will. You can't have a copy. So if I don't have the original will, when I go to probate court, then they won't accept a copy. So it's the same as not having a will at all. And in that case, every state has laws about who is going to inherit from you. Another thing that we see commonly is that people will have a will. A lot of us get a will early in life when we start having children. And so maybe after the first child, we got a will, we put that child in the will, but then we had 2 more children, but we didn't put those 2 more children in the will. So if there's no accommodation for subsequent children and your children are not all named in the will, then the ones that aren't named are disinherited. And if you don't have a guardian for minor children, they'll become a ward of the state until the courts decide who will be the guardian to take care of them. Most parents are pretty particular about who they want to raise their children, and do not want to have somebody that can just go in court and get the best attorney or has the most money to fight over a child. You want somebody that has the same values as you do. So this is really important. If anybody has minor children, they really need to have at least a will to say who they want to be the guardian. The other thing about that is once the court gets involved with a minor child, the court is involved for the rest of their life until they turn 18. So every year, whoever is the guardian has to send in some paperwork saying what's happened with the child during that year, how much money have they spent on what's their budget for the next year, and the court has to approve all of that. And so a lot of families want maybe something different or special for their child, and if it is not in the will as to who gets to make that decision, then you've got somebody that you don't even know in the court system making that decision. So for example, if you want your child to be in Little League, and that now is gotten to be pretty expensive, you need a few $100s for that, you have to get that few $100s approved for your child to be able to do that through the court system. It's pretty amazing what people have to jump through. So this is really important. Dirty secret number 9. Your estate plan fails if you don't plan for taxes. So there's many ways to minimize taxes if you plan in advance. But otherwise, you've got inheritance taxes, capital gain taxes, income taxes, and beneficiaries don't get their inheritance until after your funeral expenses are paid, your debts are paid, your taxes are paid, and your attorney fees and court fees are paid. All of those things are taken off the top before the money ever goes to the beneficiaries. And I have a friend that says this saying, and I'm borrowing it from him, that we all do have to pay taxes, but we don't have to leave a tip. So we don't need to pay more taxes than we have to, but you got to plan to minimize the tax burden. And the final one, dirty secret number 10, is your estate plan fails if you have not created one. So amazingly enough, the AARP reports that more than 60% of us do not have a will or an estate plan. But at the same time, we say our number one priority is to not become a financial burden to our loved ones. So that's a huge disconnect there, because you're going to be a burden on your loved ones if you don't have a will or an estate plan. You've got to plan for these things. And most of the people don't plan because it's something new to them. And it's a unknown territory.
I don't know if that's here, but I think we've got pretty well.
We've got somebody in the background speaking there. If you could help me with that, please. So what happens when a will fails? Well, it's the same as not having one at all. So in the state of Georgia, if you're married and you die without a will, all of your assets do not go to your spouse. If you have children, if you don't have children, it does all go to your spouse. If you have one child, then your spouse gets 50% and your one child gets 50%. And it does not matter what age your child is. If you have two children, you all split a third. And if you have three children or more, then the children get 2/3 and your spouse gets 1/3. So you can see where that isn't what most of us want, because I don't know about you, but my children have not ever really contributed to my estate. They're more of a subtraction from my estate. They don't pay a house payment. And in reality, if you don't have a will, then all of a sudden you could very well own your house with your children, or not you, but your spouse could own your house with your children, which is not a good situation to be in, because somebody has to buy someone out. And we all think, well, surely our children would give it back to us. And I do see that our children typically would, but there's a lot of times an in-law in there that won't give it back. So if you want to make sure that your stuff goes to the right people, and as easy as possible, as quickly as possible, you'd want to have a good estate plan. Probate court in the state of Georgia takes 6 to 9 months and costs thousands of dollars. And that's when the courts are open. The courts have now been closed for 4 months, so there's a significant backup, and it's going to take even longer to get through that process. But if you have a valid will or estate plan, then you decide who gets to be the one to carry out your wishes. And I'll tell you, not all people are good executors. I have one family that one child, he was the oldest, was named the executor of mom and dad's will for both of them. Mom was the last one to die. She died 10 years ago, and this son has taken no action. So the house is still sitting there. Nothing at all has happened with the estate, and he's the executor, so he's the one that needs to take that action. So don't put a procrastinator on this role. You also will get to decide who gets your assets and what percentage, what time frame, and what type of assets you want. You're going to eliminate some unnecessary legal costs, and then your loved ones are going to have so much more clarity, which really helps reduce the family feuds and the stress and anxiety. There's, the children that really want to do whatever we wanted as parents, but a lot of times they don't know what that is. And then they're busy with their job and their family and maybe even their in-laws, trying to get all of this taken care of. And if you don't have a will, they can't get to your money until they get into the probate process, probably about 6 months. So they can't pay the house payment or the utilities and stuff at your house because they don't have your money. They have to pay it out of their own money. So your loved ones will get their inheritance much quicker, much easier, without a lot of stress if you have a will that's valid and an estate plan. So without a will, there is a way. It's just not the way that you wanted. So at Nelson Eldercare Law, I'm just going to tell you a little bit about us. We preserve seniors' rights in decision-making and independence, and we protect them from what we've found people fear most, which is running out of money, becoming a burden on their families, and losing their hard-earned life savings. I'm going to open it up to questions now, Dawn.
I have one. I'll start. You mentioned a recent financial POA. What do you consider as a recent one?
That's a very good question. And it's actually not a legal requirement, but the banks and financial institutions don't like to take anything over 3 years old. So this is really a dilemma when somebody is diagnosed with some cognitive impairment, because we know that that can last longer than 3 years. And so that's why I like to talk to people early on when they have the diagnosis, so we can start getting things out of their name. We can file the financial power of attorney with the banks, etc. So everything's set up and you don't have to worry about it being too old in a few years. Great question. Thank you for asking that.
I have a question. Is it possible to have joint executors, or is it always just one?
Good question too, Nancy. So it is possible. I do not recommend it. So at the time when someone is an executor, they're mourning and grieving and going through a very emotional experience. And all of a sudden they got this huge responsibility put on them. So they're really feeling a lot. If you have two people, they have to act in tandem. So that causes some issues in that if they don't agree, then your estate plan is going to fail again, and you're going to end up going to court to fight it out. So I like to have one decision maker at a time. So that way, there's no way that we're going to have a draw, so to speak.
Mm-hmm.
But I like one and then the other. So if you have two, you could put one as the primary and one as the backup.
I have a question.
Okay.
What's the difference between an advance directive and a living will?
That is a good question. So in the legal world and in a lot of professions, we use different terminology to name the same type of things. But an advance directive for healthcare really is equivalent to a medical power of attorney. A living will is different in that a living will is for when you are alive and you have some terminal illness, no chance, no way you're going to improve, and something is prolonging your life artificially. The living will says, if I'm ever in that situation, then I want the plug pulled. I don't want my life to be extended without any quality of life. Sometimes that's part of the advance directive for healthcare and part of the medical power of attorney. But what the difference is then whoever you've chosen as your agent, which most of the time is someone close to us, has to make that final decision whether to pull the plug or not. And I find it's much easier on loved ones if they're following our decision that we've already made and written it down, that if this ever occurs, then I want my life to be ended, is much easier than maybe my kids or somebody trying to make that decision for me and live with that decision.
Thanks.
Anybody
I
else?
have a question. Can you hear me?
Mhm.
I can.
Okay. Say my spouse passes away and it can't go, I have a will and everything, but say it can't go to probate for months. His Social Security would end. What would I be living on if I couldn't, if it couldn't go through the court for months?
Yeah, so Nancy, there's two different things. So there's the transfer of assets, and then there's the income. And so as far as the income, if your spouse had a higher income than you, then you can actually, or a higher Social Security, you can actually get their Social Security instead of yours. But if you owned assets together, let's say you had a joint bank account. If your spouse passed away, that bank account is still yours.
Okay.
Whoever is the survivor gets the bank account. If your spouse had a bank account in their own name, then no, you can't get to that money until you get through probate court. And that's the dilemma that I think you're referring to is, so now what do I do before probate court ends? What assets do I have to live on?
Mm-hmm.
Well, yeah, it's a difficult situation, and it's a good reason to avoid probate court. Because
So how do you avoid probate court?
pardon me?
How do you avoid probate court?
Let me answer that in just a second, because I want to say something else about the house. So if my spouse and I own the house together and he passes away and his estate has to go through probate court, I can't sell that house. I have to keep staying in it and paying for it until we get out of probate. There are tools that are called trusts, which are a great way to avoid probate court, but it really depends on what kind of assets you have in order to avoid probate court. And a lot of people think, well, okay, I've heard of a trust, but that's just for millionaires. And it's really not. It's a way to make life so much easier on your family than going through probate court. And if your family starts to have any issues, you're going to be in probate court a long time. My brother died 4 years ago and we're still in probate court. So it can take a long time and cost a lot of money.
But it costs a lot of money to get a trust, I found out.
Well, it can be a few $1,000s to get a trust, but it's actually cheaper than going through probate court, and it's faster.
Okay.
And if you're married, a trust can work you need one trust for you and your husband. So you would be avoiding probate court twice if you have the right kind of trust.
Barbara, did you have a question?
Yes, I had a question. Thank you. I was wondering how you handled the disposition of an IRA account. They changed the rules. You have to pay out an IRA within 10 years. And I was wondering if you put that IRA in a trust, especially if you had a young son that would get that IRA. How would you handle that? Would you put that in your residuary estate? Because then it would be taxed, totally taxed. I don't understand how would you handle that?
So every situation, every family has different needs. I don't like a child under 25 to get any lump of money because they really don't have the capacity and the financial wherewithal to manage that. And so I do like anything that's going to anyone under 25 to be held in a trust for them. When it comes to an IRA, you do have the tax implications, but it could be that it's paid out over the 10-year period to the trust rather than to the child itself so that you could minimize taxes, because if you take it all out at one time, I mean, the thing with an IRA is no matter when you take it out, somebody's got to pay taxes on it.
Right.
You're going to pay taxes if you take it out while you're alive. If you leave it to, anybody else, they're going to pay taxes on it. It's just a matter of how can you minimize the amount of taxes that you have to pay on it. Did that answer your question, Barbara?
Yes, I think so.
Okay, thanks.
Can I ask something about that? So
Sure.
a trust can be a beneficiary. Is that a true statement?
Yeah, the way that a trust works is that you've got the will, because you still need a will, but instead of it going to probate court, what happens is everything you own when you pass away goes into the trust. And so it can be distributed as soon as you get a death certificate, which is typically a couple weeks or less. And that can skip, if it's set up properly, you can completely skip the probate court process.
So what would be the downside of getting a trust?
It's what was brought up from Nancy, is that, you're going to pay a few $1,000s now to get it set up, or you're going to pay several $1,000s later to go through probate court. And again, if you're a couple, you're going to skip it twice. But not all trusts are created equal. So even though all legal documents are called the same thing, like a trust or a will or a power of attorney, they're not all the same. It's like saying, that all cars are the same, where every manufacturer has a different type of car and different benefits and features. And that's how it is with all of these legal tools that we're talking about. So it's not like every trust is equivalent to another. The reason I say that is because in the trust that we do, we make sure that we preserve your homestead exemption. Because many of us that are over 62 get a break in our taxes. Not only do we get the homestead exemption, but then we stay for the school tax exemption. So if that isn't preserved in there, which I've seen a lot of trusts that it's not, now you've got several $1,000s you're paying every year in additional taxes to have a trust. Another thing is there's a IRS provision, and I'm not a tax guru, but there is something that says if you sell your house after you lived in it for 2 years or more, and you have some capital gains, you don't pay taxes on those up to $250,000. Well, we preserve that IRS exemption for you too, because if you sell your house, we don't want you to lose that just because it's in a trust. So those are a couple things that, if not written correctly, would cost you more to have a trust than if it was written correctly.
So we had a trust when my parents passed, and there was quite a fee associated with it each year.
Oh,
So I have those. I mean, that was quite a long time ago. So have things changed from that?
again, I would say it's all about the creator. There's no fee associated with the trust that we create. There's no annual fee at all with that. But I do know of trusts that then the attorney gets some annual fees from it.
I have another,
Okay.
and this might open a can of worms, but I've heard two different terms, a Miller trust and a QIT trust.
Yep. And so
Are
again,
they the same thing?
they are the same thing.
Okay.
And so let me explain what those are used for, because those are a trust for a very specific situation. The only time those are used is when somebody is trying to apply for Medicaid, but their income is a little bit too high. So right now it's about $2,300 that Medicaid will allow you to have an income and still qualify. Now they have a lot of other requirements, but just on income, the restriction is anything over $2,300, you can't get Medicaid. But if you're in a nursing home and the cost is $8,000 a month, I mean, you can't pay that on $2,300 a month of income. So there's kind of a extra loop or step that you have to take where this other trust is created, and it will allow you to still qualify for Medicaid even if your income is over $2,300. But that's the only time those two trusts, it's the same trust, a Miller Trust or a QIT, Qualified Income Trust, is used. Good questions.
Yeah, excellent. Anybody else?
Oh, me again. Sorry. But a trust is an individual. Is that a true statement?
No.
Or it can be.
Well, a trust is a legal entity.
Mhm.
One of the ways that I found people understand it, because I didn't know what a trust was before I started doing this, I always just thought that some rich people had a trust and their spoiled rich children got money from a trust fund, right? That's all I knew about. And I didn't grow up on that side of the tracks, so we never had anything like that. But I found out that really they're for the average person as well. And so a lot of us have never heard of them or don't know what it is. So if you look at a business, I am a business, I have a business, Nelson Eldercare Law. But at any point in time, Nelson Eldercare Law could become a corporation. And the only thing that makes it a corporation is a legal contract that I think of as a wrapper around my company. And so that's what a trust is like a wrapper around some of your assets. And, you know, there's attorneys that tell you you have to put everything into the trust whenever you set it up. And so that means like changing your bank accounts and changing the title to your car and all of this. You don't have to do that. We don't do that. Really, the only thing I need for you to put in the trust immediately is real estate. I can make everything else transfer into the trust after you pass away, so you don't have this burden of going to, you know, rename and reshuffle and all of that stuff. We make it very easy on you. And then recently we've started with a new team member that actually will help you get the trust completely funded. And now what does that mean, funding the trust? So I told you these other things don't need to be in the trust, like your bank account. But your bank account has to have a beneficiary on it. So if you or when you die, the money that's in that bank will automatically go to your trust. So my funding manager, her job is to go to the bank with you and make sure that gets set up right so that it will work the way it's supposed to. There's a lot of things that I see with trust, and I could probably do another presentation about the 50 things that go wrong with trust if they're not set up right, because I see a lot of trusts that are never funded. And so if I have this wrapper around my business, but I don't have all my business, you know, covered under that wrapper, I just have this little portion, it's not going to work for the whole thing. I got to have it set up so that it works for all of it. But what every other attorney does is says, here's a list of things that you have to go do after we set up the trust. I only know of one attorney in the whole US that does it the way that we do, and he's in Sacramento. And that's with the funding manager. And so if you have this list of things that you have to do afterwards, guess what happens? They don't get done. Life gets in the way. And it's, again, things that we're not really familiar with. So I know the first time that we went to the bank and we asked the bank, it was a personal banker, to help us to put a beneficiary on this client's bank account. Well, the personal banker had never heard of that before. They ended up having to get on the phone with legal about 3 different times. We were there for 2 hours. They really wanted to open us up a new account, which that's not what we wanted. So, you know, even if you did go to do this list of action items that you were given, they're not going to be done successfully because the people that you're dealing with are not familiar with this either. And so it just ends up being a mess. You get frustrated and then you don't follow through on it. And then what happens? The trust doesn't work the way that it was supposed to, and your family still goes through probate court. So that's something that I think makes a big difference is you've got to have the right trust. It's got to be set up the right way with all the provisions in there. And then it's got to be funded the right way. And it's got to really, there isn't anything to maintain, but let's say that you put your house in there today. Let's say I lived on Smith Street and I want to sell that house. Well, I can sell the house while it's in the trust. That's not a problem. And if I'm going to buy a new house over on Maple Street, I'm just going to get it deeded in the name of my trust right away. So I don't want it to be outside of my trust. I want it to be in the trust immediately. And those are the things that you just have to, you know, have someone help guide you through that process. So great questions. I love the questions. Thanks for asking them.
I have a question, please. If there's an estate with where the proceeds are to be split evenly amongst surviving children, and one of those children was named the executor, are they legally required to provide some type of an accounting to the other siblings of what assets are to be split equally amongst them?
Boy, this is a common question too. And it really depends on what the will says. And this is part of what I'm saying is that not all these documents are created equal. A lot of wills that I see are 2, maybe 3 pages. And so they don't have a lot of the protections in there that I like to see in a will. Ours is like over 20 pages. And I don't get paid by the word, but it's so that we have these things, you know, is the executor supposed to be compensated for that role? Do they have to do an accounting for anybody else that is receiving assets? If it goes through the probate court process, then yes, they do have to do an accounting and they have to sign off saying that they received their inheritance before they're going to get discharged from liability through the court system. But it really depends on what all it says in that document. And so I can't tell you without seeing the actual will.
Okay. If it was basically a pretty simple, straightforward will, and most of the assets of the estate have been dispersed equally amongst the siblings, but one portion of the estate hasn't been dealt with, and it's not an insignificant amount of money. They're savings bonds, and the executor simply has not dealt with them, and the last parent passed away 8 years ago. Is there any responsibility on the executor's part, any time frame? Do the siblings have any option to apply any pressure to their other sibling, the executor, to 8 years later, let's get this done?
Yeah, so I'm going to pick that apart a little bit. So we all think that our life is simple and that we just need a simple will, right? That's
Right.
what everybody says. All I need is a simple will. I don't really have much. And it isn't like based on the dollar amount that you have or even the number of children or anything like that, but it's about bringing clarity to how these things are going to work after you're gone. Now, I think people that have property in more than one state recognize that that's not simple. And just to let you know, if you have to go through probate and you have property in Georgia and in Florida or any other state, you're going through probate twice, once in Georgia and once in the other state. That makes it twice as expensive. So that's much more complex. But we all think our life is simple. So be careful when you think, I just need a simple will. And then as far as, is there any responsibility for this executor to take action? Again, what does it say in the will? And I think in this case, since it's been 8 years, that you're in a dilemma, because if you get too pushy with this sibling, then you know that that's going to deteriorate the family relationships forever. And if you don't, then they might sit on it forever and you don't understand what the issue is. So I think the first thing that I would recommend is, I'm sure that you've tried to talk to that person, maybe try to get a mediator involved. And if that doesn't work, where you guys can come to some agreement, the only other avenue is that it's going to be a failed will and you're going to have to go to the courts to get action.
And that sounds like something probably expensive.
Probably.
Thank you.
Sure.
Cindy, can you hear me?
I can.
Oh, okay. What did you mean, or can you talk a little bit more about with a trust, preserving homestead exemptions and say, for example, the Cobb County exemption that we have for people over 62, where would that be in the trust? Or, I mean, how would that be included?
It's a provision that we write some legal mumbo jumbo in there to make sure that you still get that.
Okay.
So it isn't in like a specific place, and it's just something that we include in our trust because that could be a significant amount of money. I know it makes a big difference in my taxes every year.
Yeah. Okay. Thank you.
Mm-hmm.
If you get a chance to do one on, discussion just on trust, that would be
okay.
appreciated.
I'm always looking for good information that, I have the curse of knowledge. Once you learn about something, you know it, so you just feel like everybody else does. So it's good to know what you'd like to hear about. So thank you, Tanya, for that.
Well, Cindy, you did an incredible job using the analogies and making it very easy to understand. So everybody, thank you so much. That was truly fantastic. Obviously, very well versed and educated. And I think the key thing is it's so easy to listen to you because you do make it plain and simple for everybody to understand. And I agree with Tanya, trusts are absolutely one thing people are very confused about. So maybe we'll be fortunate enough to have her come back. I would strongly, she's been a huge supporter of Aloha to Aging. She's been on our board. It's a beautiful gift. Her Nelson Eldercare has grown. Her son Josh is now in Woodstock with at that location, and she's in Marietta. So I would strongly recommend contacting her for any of these things and questions. As you can see, she's very approachable. So thank you all so much for being part of today. Cindy, do you want to say anything else?
I do. I want to say thank you to you, Dawn, for what you do for people that have cognitive impairment. I think that I don't know if everybody is familiar with Aloha to Aging or not, but if you're not, it's a life changer for people that have cognitive impairment and their families, because it's a way for them to still have some socialization with other people like them, but also for their families just to get a break. And if any of you have been a caregiver, I feel like that is the most challenging job that any of us will ever have. And I see caregivers come in here all the time And they just need to be able to walk away with the comfort that not only is their loved one well taken care of, but they're having fun. They really enjoy going to Aloha to Aging. It's really great to see them all enjoying it. So Aloha has, and Dawn's the one with the vision that has created something that nobody else has. I don't know of any other place that does anything like it. So I always like to support Aloha. And thank you all for coming. It's been a joy to talk to you. Great questions. I appreciate that. And I will do something on trust. So you'll see me again.
Great. Thank you.
Thank you very much.
Great to see you all. Thank you so much for your support.